You're welcome to the class. Today we'll be looking at the functions of the court. In our previous class, we looked into the general tort system. We also look into the computer crimes. We look into examples of business crimes, making false statements, defraudment, wired fraud, tax, kickback scheme, cheating, and the rest. But today we'll be talking about the functions of the court, the various type of court system in Nigeria. We'll also be looking at the differences in the court system of Nigeria. We'll be looking at the major antitrust law and their differences. We'll also go into the law of contracts, whereby we'll look at what a contract is, how do you write a contract. We'll look at jury trial and the rest. Now let's go back to functions of a court. Functions of a court. We know a court is a tribunal or a government institution with the authority to adjudicate legal disputes, that's to settle legal disputes between parties and carry out the administration of justice in civil, criminal, and administrative matters in accordance with the rules of the law. Now, the functions of the court are their means for dispute resolutions. Courts are means for dispute resolution, provision of rights for persons accused of a crime to present a defense before a court. The courts play an integral role in upholding constitutional rights. Judges have the power to strike down any law that violates the Constitution, or they may order the government to amend the law to make it consistent. Now, the courts may be called upon to interpret the Constitution on matters of jurisdiction and also to decide which level of government is responsible for implementing a policy or service. These are the four functions of the court. The court is there to settle disputes in civil and criminal cases. The court is there to provide for a person the right of a crime to present a defense before a court. Even if the person is guilty, the person has a right to present a lawyer to defend his case. Now, the courts also play an integral role in upholding constitutional rights. That is, the judges have the power to strike down any law that violates the Constitution. So all these are the functions of the court. Let's look at the relationship of the various courts. The judicial powers of Nigeria are conferred on the court. That is, the Constitution of the Federal Republic of Nigeria since 1999, as amended, expressly recognizes the following courts as superior courts of record in Nigeria: the Supreme Court, the Court of Appeal, the Federal High Court, Abuja, a High Court of a state, the National Industrial Court, the Sharia Court of Appeal of the state, a Customary Court of Appeal, Magistrate Court. These are the various courts in Nigeria. We have the Supreme Court, the Court of Appeal, the Federal High Court, the National Industrial Court, the Sharia Court of Appeal, a Customary Court, the Magistrate Court, and a Customary Court. All judiciary or judicial processes terminate with the final decision of the Supreme being the highest court in Nigeria. That is the highest court in Nigeria. So the Supreme Court is the most powerful court among state courts. It began functioning in 1963 after Nigeria was declared a federal republic following the settling of a constitution which became relevant in October 1963. So the jurisdiction of the council was abolished with the cancellation of Section 120. Therefore, the Judicial Committee serves as apex court. That is, a new view of the court was set forth in Article 230, stating that this institution is headed by a chairman with whom 21 judges works. Thus, their decision is law and must be fulfilled. Repeated reviews are not practiced except in cases when the president and the governors are examined. So in such situation, any person who is considered to have violated the Nigerian legislation may be granted a reprieve. Also, the Supreme Court rulings can be revoked by law or by the Supreme Court itself. So it is participants decided to change their decision. Now, the Supreme Court is the highest court in Nigeria, and it started in 1963 after Nigeria was declared a federal republic. This court, the essence of this court is headed by a chairman and a 21 judges under him. Their decision is law and must be fulfilled. And the Supreme Court can revoke any law by itself or by any other participant. So the Supreme Court reserved the legal right to prevent any other Nigerian court from carrying out a hearing. So let's look at the Court of Appeal. As several units located in different regions of the country, they have different centers in the country. The Court of Appeal. The Court of Appeal is a decisive force when it is necessary to establish whether results are correct following governorship or presidential election. So after a result has been made via other Nigerian courts, when it comes to appeal, this court has the same unlimited power as the Supreme Court normally has. So it considers results of the collation of ballots and appeals of all civil jurisdiction. The Supreme Court is there and is created in Section 237 in 1999. So it is headed by a chairman who has 49 judges working with him. So the Supreme Court also have the same unlimited power as the Court of Appeal has the same level of power as the Supreme Court. So the Court of Appeal was established to help following or in correction of any form of election like governorship or presidential election. That's after a request must have been made to the court. So let's look at the Federal High Court. Federal High Court exists all over the country. They are located in more than 15 regions. So the existence of this judicial body is prescribed in Article 249 of the Constitution. The leading position belongs to the Chief Judge. It also has a number of other judges working under the instructions of the National Assembly. So the court can function correctly only if it contains at least one judge of court. Jurisdiction for civil cases is prescribed. Jurisdiction for civil cases is prescribed in Constitution section number 251. There is an jurisdiction as well as all power of the state, questions of interpretation of Constitution, observance of human rights, relations between bankers and their clients are considered in this institution. The Federal High Court holds the power to function correctly only if it contains at least one judge of court, and its jurisdiction is to help with the interpretation of the Constitution, of observance of human rights, relation between bankers and their clients. Let's look at state court, high court. The state high court. It can also be called the high court. The establishment of this organization, in Abuja is prescribed in Article 255 of the Constitution. It is led by a chief judge who also has a number of other judges working with him. So the High Court has major rights prescribed by the Constitution over several matters in the country. This applies to criminal and civil proceedings, appeals as acceptable for decision of district magistrates and other less significant courts. So the state high court can be called the high court, and their work is to apply and their work applies to criminal and civil proceedings. Any criminal act is taken to the state or to the high court for prosecution. National Industrial Court. This is the law of the National Assembly prescribed a number of judges to work under the National Industrial Court. It also has various departments providing administrative convenience and also offices location in some regions of the country. The staff of this court are mostly involved in civil proceedings and other aspects prescribed by Article 254C. The work of the National Court Industrial Court is to help with various administrative convenience and also offices location in different areas. And it also involves civil proceedings and other aspects prescribed in Article 254. Let's look at the Sharia court. The creation of this organization is prescribed in Article 260 of the Constitution article, which refers to a free establishment of such institution in any region located in Nigeria. It is headed by a Grand Cadi and also has a number of other Cadis working with him. The court is concerned with the affairs of citizens if they concern Islamic personal rights. Now, the Sharia court is an Islamic court, and they are to work, or they are concerned with the affairs, the relationship of their citizens, especially the Islamic society. So they help to regulate disputes among families, among individuals in Islamic way. Now let's look at the customary court of appeal, which is this organization is described by Article 265 of the Constitution, and it was also created to service the Federal Capital Territory. So the Article 280 describes the possibility of forming such an organization in any region that is a part of Nigeria. It is headed by a president, and the National Assembly determines the judges to work with him. It is involved with civil proceedings when it comes to customary proceedings. That's the work of the customary court of appeal. The magistrate courts aren't prescribed in the Constitution. So the magistrate court performs summary judgment without statements and instructions from the parties involved. The district and magistrate court have similar functions, but the first name is most often used in the northern part of the country, while the second in the southern areas. So all of them are engaged in civil law, and each region has its unique rules. So the magistrate court and the district court, they have similar functions. The district court is mostly used in the northern part, while the magistrate court is used in the southern areas. So all of them are engaged in civil law, human rights, disputes between individuals, companies, and the rest. Let's look at the last one, which is the customary court. Has jurisdiction over persons who are subject to customary law. So there are various customary court law across the state in Nigeria. The customary courts are constituted by these laws. They have power with respect to bylaws of local governments and the contempt in face of the court and powers that are prescribed or expressly conferred upon them. The magistrate court has jurisdiction over an individual, those that are subject to the customary law, and they also have powers with respect to bylaws of local governments, contempt in face of the court, and powers as expressed and confirmed conferred upon them. Let's look at the procedure. What are the proceedings? The procedure for filing a lawsuit. How do you file a lawsuit? What are the procedures? There are several reasons that one might use to sue someone. They may owe you money, they may have breached the terms of an agreement you entered. They may also have damaged your properties or your reputation. So they have injured you on purpose or by accident. So there are steps in filing a lawsuit. The first step is to demand. Typically, there is a dispute and one party will make a more or less informal demand of the other, who would then send a response. This may lead to informal discussion. A lawyer can help you assess whether what you are requesting or offering is realistic and help you avoid making admissions that can hurt you if you can't agree on terms. Now, the first step is that there must be a demand, either a demand for a money owed, a demand for a lend items, a demand for justice. So there is always a demand, and a lawyer is always there to help an individual to assess whether the lawsuit or what is bringing up or what is requesting is realistic or not. There's a lawyer's letter. The second one is the lawyer's letter. Now, if the principal can't work this out among themselves, that's if those demanding for justice cannot settle indoor, one party usually has an attorney send a lawyer's letter. While there may be any legal significance to a lawyer's letter, it is usually get a serious response from the other side, which may have been ignoring you. So the first party or the second party might decided to send a lawyer. He might decided to send, might decided to send his lawyer to file a lawyer's letter, to send a lawyer's letter to his opponent. The second action is pre-litigation statement discussion or settlement discussion. Sometimes it takes a lot. It takes a letter and also phone calls to straighten out a dispute, particularly if the other side sees that you are serious. So it takes a lot to settle a dispute. So a party might decide that, okay, let's send a letter or give a phone call to straighten things up so that the case will not move on to the court. The next step is formal suit. If the informal attempt at resolution fails, formal action may be stated or started by filing suit. The formal litigation is on the way. There are strict statutes of limitations which impose time limits requiring that actions to be initiated within a set time frame or the right to sue the bar. Now, the formal suit is if the informal attempt of resolution, that's the pre-litigation settlement discussion, if it fails, then a suit will be filed. Now, answer: once the defendant is served with legal process, it must provide its formal answer within a prescribed time frame. It might be within 2 days, within a week, within a month. It all depends. Like if one is filing for a divorce, other party will have to respond within a set time, within a given time stipulated in the letter. Now, if the defendant does not answer on time, it is said to default and generally will automatically lose its case. So if the defendant refuses to respond, automatically the defendant will lose his case. Sorry. The defendant will lose his case. Let's look at the next one, discovery. A lawsuit might or may involve pretrial discovery in which one or both parties attempt to get evidence as to what happened, perhaps by taking the testimony of witnesses or examining documents or physical evidence. Discovery, that after a lawsuit may also involve pre-trial discovery. That is, one or both parties will attempt to get evidence either through a witness's testimony or documents, examining documents and the rest for physical evidence. Let's look at the next one, which is motion. In a lawsuit, either side may make motion to try to narrow the issues or compel the other side to do something, or even to have the court decide the matter without the need for a trial, as if all the facts are agreed to and only the application of the law to the fact is at issue. And that's the motion. Either side of the either the defendant or the person applying for the lawsuit can decide to make a motion to narrow the issue, that is to compel the other side to do something or to even have the court decide whether the matter can be whether the matter can be resolved outside the court. Judges pre-trial conference. Before a trial, the court will typically order a pre-trial conference to narrow issues until further and perhaps to get the parties to agree to a settlement. And if that fails, the trial then comes the trial either by a judge alone or with a jury to decide the facts and the judge to decide the law. In arbitration, the trial is called a hearing. A trial is called a hearing. So after the judge pre-trial conference, that is, they try to see how both parties can agree on a settlement. But if that fails, the trial will commence and the judge can prescribe and decide the trial or with a jury to decide the fact and to also decide the law. And a trial can also be called a hearing. Judgment. After the trial, the court will enter judgment. Judgment is an arbitration. The arbitrator will issue an award and the victorious party may go to court for confirmation of the award. Now, after the trial, the court will enter the judgment, and after that, a post-trial motions and appeals can be made, which is the losing party try to convince the original judge that something else is appropriate, perhaps more money or added relief. After that, there may be an appeal by the losing party to a higher court. So collecting the judgment, the victorious party may have decided or received a judgment stating what he or she is entitled to recover. Then it is or her job to collect the judgment. Collecting judgment can be difficult, especially if the defendant's assets are not easily located or exempt for claims of creditor. So the steps presented above can take many twists and turns as the court proceedings evolves. So while a lawsuit can start as a very simple matter, it can get complex very quickly. In addition to these basic steps, there are many other steps which may be possible depending on the particular circumstances. Let's look at jury, the procedure for a jury. The procedure for a jury. The procedure for a jury. A jury is a body of persons selected to decide a verdict in a legal case based upon the evidence presented after being given instruction on the applicable law, also called petty jury, trial jury. A jury is a sworn body of people convened to render an impartial verdict, a findings of fact on a question officially submitted to them by a court, or to set a penalty or judgment. So modern juries tend to be found in courts to ascertain the guilt or lack thereof in a crime. In Anglophone jurisdictions, the verdict may be guilty or not guilty. So a panel of ordinary and reasonable citizens sworn to a panel of ordinary citizens sworn to give verdict according to the factual evidence presented in a court of law. So in some cases where there is a jury, the job of the judge is to guide them on point of law, and they should decide on point of fact. While a jury system evolved from the common law of the United Kingdom and is mostly attributed to criminal cases, in the US and Canada, jury trials are common in civil cases as well. So the old institution of grand juries still exists in some places, particularly the United States, to investigate whether enough evidence of a crime exists to bring someone to trial. That's who a jury is: a body of selected person that is conferred with the power to carry out a verdict in a legal case. Let's look at jury trial. Trial by judge and jury is composed of a single trial judge who gives legal advice on matters of law and procedures and provides legal direction to the jury members. In Nigeria, there is no current practice of civil or criminal jury trial. Yes. What we have are bench trials at every level, where the judge or judges have the final say on both facts and points of law in a matter before them. So let's look at reasons for government regulations on business. Reasons for government regulations on business. To ensure truth in advertising messages of businesses, they are also there to prevent businesses from disclosing private or sensitive information freely, to enforce the employment and labor law in organization, to save the environment for degradation of business activities, to ensure that employers provide employees with an environment free from recognized hazards such as exposed to toxic chemicals, excessive noise level, mechanical dangers, heat or cold stress, or unsanitary conditions, and also to hold businesses corporation accountable for the enormous power they exercise in the country, that's in the community. Now, the reason for government regulations on businesses are this: to ensure the truth messages of businesses, to prevent businesses from giving out private or sensitive information freely, to save the environment for degradation of businesses, and the rest. Let's look at types and powers of administrative agency. We have different types of administrative agency in Nigeria. So administrative agencies are created by the Nigerian Constitution. Both National Assembly, state legislature, and local governments manage contingency address serious social problems, and manage complex matters of governmental concern. So administrative agency actions can be categorized as one of the three types: the rule making, the adjudication, and also the investigation. In rule making, administrative agency use this process, that's rule making process, to create or to proclaim regulations. That is, legislature makes laws based on the policy mandate of the government. However, the legislation frequently find areas where it is impractical for lawmaker to apply a level of details or expertise required to constitute to common standards. So therefore, hence the agency action should be in accordance with the enabling status, while adjudication administration is exercise of judicial power by an administrative agency. Generally, the administrative agency deals with disputes between individuals. It deals with disputes between individuals, and the government in terms of benefits or disability incurred from a government. Agency adjudication is broken down into formal and informal. So administrative law judges makes a decision based on reason analysis, written findings of fact, and conclusions of law. So this decision is subject to appeal to the highest administrative authority of the agency. So administrative fact findings are binding on courts unless not supported by evidence. So the administrative are there to bridge the gap or help deals with dispute between individuals, between the government in terms of benefits sought or disabilities incurred by the government. While the last one, the investigation agency, they have the power to conduct an investigation like the EFCC. Congress may empower administrative agency to obtain information on activities which can be regulated by federal legislation. So usually the form of investigation depends on the nature of the question to be decided. So administrative agency can also issue requiring a witness to appear and to testify, also to provide any book, papers, or any document relevant to the investigation. These are the three main governmental or types of powers of administrative agency. These are the three types of powers of administrative agency. Let's look at the major antitrust law. We have the three major antitrust law, which are the Sharma Antitrust Act, the Clayton Act, the Federal Trade Commission Act. These are the three Trade Commission Act. The Sharma law, the outlaws of all contracts, combinations, and conspiracy that unreasonably restrain interstate and foreign trade. Now, the act, which include agreement among competitors to fix prices, like fixing a price of petroleum or crude oil for all countries, and allocate customers. Sorry. Sorry for the interruption. The Sharma looks into it also look into fixed prices, which bids and allocation or allocate customers who are punishable as criminal felonies. This act helps to have a common foreign trade. The act also helps, however, it's not violated simply when one
Mrs. Ruth, please, you're muted. Please unmute yourself.
sorry for that. I'm so sorry for that. We are still on the Sharma Act and the Trust Act. We talk about restrain interstate and foreign trade conspiracy. It's also based on the agreement among competitors, that every agreement among competitors should be a fixed price. It reach bids and also allocate customers, which are punishable as a criminal felony. But the Clayton Act carries no criminal penalties. It's also that prohibits mergers or acquisitions that are likely to lessen competitors. So under this act, the government challenges those mergers that are likely to increase prices to customers. So all persons considering a merger or acquisition above a certain size must notify both the Antitrust Division. So this Clayton Act helps to merge all the competitors. So in this act, there are lesser competition because everybody sells at a specific price. Everybody sells. You can't sell your product or anything you are bringing in on the high side without informing the Federal Trade Commission. So the Federal Trade, let's look at the Federal Trade Commission Act. This act prohibits unfair method of competition in interstate commerce, but carries no criminal penalties. So it also created the Federal Trade Commission to police violation of the act. So the Federal Trade Commission Act helps to prohibit unfair method of competition in interstate commerce, in the buying and selling between different states. Now, the act doesn't carry any criminal penalty, as well as the Clayton Act. It doesn't carry any criminal penalty. But the Sharma Act carries a criminal penalty, which is punishable as a criminal felony. Let's look at the federal government legislation on environmental protection. Please, I want you to read this. We have all this legislation, we have all these agencies within the country, so you can just go through it yourself. Let's go to the law of contracts. Sorry, I have few minutes. I have just a minute. We'll look at the definition of law of contract as a legal enforceable agreement between two or more parties. So your assignment, please write on the law of contract in details. Write on the law of contract, the differences between contract and agreement, the type of contract that exists. look at right on the requirement of a valid contract. So just go online, get or go on Google, look into the law of contract. So we'll be meeting in our next class because we are unable to round up in this class. We also have another class. Thank you for your time. Mr. Yomi, thank you for the coordination and also for your time. So have a nice day. Bye.